to the Welcome to the Afternoon Constitutional, where we put together this little program for you via YouTube. And so far, we're stuck on one strike. We've only managed to offend the network censors one time. Um, but we'll have Dr. Marek back on again real soon, I'm sure. Today's program, in honor, I wore black today, not for a dire thing, but because it's in honor of our esteemed Supreme Court justices. And we're going to spend a bit of time talking about their flurry of rulings. I promised you yesterday that we knew some of the folks who were quite familiar with what was going on at the Supreme Court, and we're going to continue that theme with some of the rulings that they came down with just today. But joining us from the Manhattan Institute is Renu Mukherjee. I'm sorry, I've added an R to your name, Renu. I apologize for that. No extra charge for the extra consonant. It's Mukherjee, correct?
Yes.
Okay. I pride myself on guessing pretty well. Just don't go to Las Vegas with me. She is with the Manhattan Institute, and I appreciate you taking some time out to talk about the ruling that came down regarding the affirmative action case. And I think particularly we're interested in a couple of things. And one of them is, I think, to me anyway, an obscure part of Justice Roberts' majority writing, and in which he talked about the experiences of the students. And I was concerned that that was not just a loophole, but a barn door to not stop race-based admission standards, but create a scenario where they're almost going to be impossible to find. Am I wrong to be concerned about language like that?
Thanks for having me on, Joe. And you're certainly not wrong. That paragraph in the holding and also later on in Justice Roberts's is in opinion does suggest that through application essay questions, for example, colleges and universities can encourage students to write about their race and ethnicity. And the qualification he puts on that is going to be pretty easy, I'm anticipating, for schools to go around, which is he says, in his opinion, that you can, in an essay, for example, write about your racial or ethnic background, but the school could only admit you if you, in writing about that, it was tied to, for example, overcoming discrimination. And so the emphasis would have to be based on the act of overcoming discrimination, but not one's race. That's an extremely fine line to walk, and one that I'm sure colleges and universities are certainly going to overstep. So yeah, you're definitely right about that.
And why do you think that was? I mean, to me, it almost smacks of internal politics, where the chief justice was trying to get six votes together and said, "Okay, okay, okay. How about I give you this?" So that the university professors that are in your family or in your circle of friends don't holler at you or kick you out of the club. Why do you think they left this kind of barn door in which could have been a very simple ruling? I've got to think, Renu.
So my thought on this actually came out of a contentious exchange during oral arguments back in October between the attorneys representing students for fair admissions and Justice Ketanji Brown Jackson, but also Justice Amy Coney Barrett. She seemed concerned, Coney Barrett, about differentiating between what she referred to as check the box consideration of race and a more holistic consideration of race. So she, in fact, was putting that line of argument forth to the attorneys representing students for fair admissions. And then on the flip side, Ketanji Brown Jackson also was discussing how it could perhaps be troubling if students could not write about their race at all. And so I think because that was such a central aspect of the oral arguments, and it actually was something that students for fair admissions said themselves, striking down Rudder versus Bollinger would not necessarily prohibit, in their opinion, students from mentioning their race in an essay question when talking about adversity or family background. I think because of those moments in the actual oral arguments, Chief Justice John Roberts felt the need to address it in his opinion and potentially created a loophole.
Well, and I think what you speak to, Renu, is really one of the issues I have frequently when we turn to the government and say, "Well, the government will fix this for us," because this seems to be a fix that creates a similar problem, if not the same one, whereas it could be very simple that you can't make a decision and maybe that's too hard of a thing to prove. Making a decision based on somebody's race or ethnicity. I guess I oversimplify things, not being a lawyer. Where do you sit on what would have been a better fix for this ruling?
I think, the real opinion to hone in on is Justice Clarence Thomas's concurrence, where he
Mm,
actually says, he writes the words, for all intensive purposes, Grutter is overturned. Grutter
okay.
from 2003 holding, that schools can use race and ethnicity as a factor in admissions decisions. John Roberts does not use that language. He basically says, the schools, Harvard, UNC, other colleges and universities have not adhered to strict scrutiny. They haven't shown empirically, one, that you can actually prove there are certain educational benefits of diversity being achieved, and two, that them giving preferences to certain racial minorities while discriminating against Asian and white students is somehow connected to these benefits. So he basically all but strikes down Grutter. He doesn't say that though, whereas Clarence Thomas actually goes as far to sort of suggest we ought to do away with this. And so that's why I think
Mhm.
Clarence Thomas's concurrence is quite seminal here.
As it frequently is, and
Yes.
Rena, you mentioned Amy Coney Barrett was one of the participants in this back and forth concerns about not ever being allowed to mention your race or your history if it might include some reference to race. How do you avoid that? How do you write law that says, "Oh, you can never mention your race"? I mean, I guess what the ruling comes down sounding like is like, listen, if you got to mention it, but the schools can't use it as a final deciding marker. Is that a fair way to look at it?
It definitely is. And that really, Joe, what you just said gets to how difficult it's going to be. Well, it's going to be easy for schools to get around it, but difficult to force schools to adhere to this standard, because if a student writes about his or her ethnicity, and the rule that Roberts has laid out is that you can accept the student, but you have to make clear the reason you're accepting them is because you were impressed by how they overcame adversity, not because they're of a preferred racial
Mhm.
minority group. That's going to be the school's just going to say, well, we actually focused on the act that the student did. We're not focusing on the race. So it's going to be a lot of, I think, he said, she said sort of with this. It's going to be extremely hard for schools to actually kind of follow the standard, and easy for them to in fact get around it.
So, Renu, we're talking with Renu Mukherjee. I don't know why it's my New York background. See, we leave ours off of many words and then
Yeah.
add them where they don't belong. Another thing. She is a pulse and policy analyst at the Manhattan Institute, and we're talking about the Supreme Court ruling here. And I watch this in law enforcement frequently. After the president several years ago said, "You know what? I'm advising my law enforcement community to not enforce certain laws. We're going to leave what kind of laws they were out." But the president of the United States, from behind a podium, said, "I'm advising my law enforcement agencies to not enforce certain laws." Opening a whole Pandora's box, I view, of a world where you have this kind of interpretive dance of why somebody picks somebody, why somebody arrests somebody, why somebody prosecutes somebody, why somebody admits somebody into college. How does a college write its admissions policy, taking this ruling into account? How do they write that, and then how do they live up to it? And what happens when a student says, "Well, hold it, I had a perfect SAT score. How did I not get into the University of Virginia?" And then what does the university wind up having to say?
So I think what schools are going to do, and interestingly, they clearly anticipated their ruling because they've already been addressing it in advance of what came down yesterday, is, for example, getting rid of objective measures of academic preparation and merit, because that might lead to a racial composition of their incoming classes that they're not satisfied with. So schools have got in March, for example, Columbia became the first in the Ivy League to get rid of its SAT and ACT requirements.
Hmm.
The University of California in 2021 finally came to the decision to permanently ban consideration of standardized tests. So they became test blind, not test optional, meaning if you send your test scores when applying to a school within the UC system, they will just throw those scores out. And it's clearly because, for example, Asian American students score in a certain often score in a certain percentile, for
Hmm.
example, and then, for example, African Americans, they would not score in that same percentile. So that's one way schools might do it. Another way are racial proxies, so race neutral alternatives that, in fact, in theory, they are pure race neutral, but
Hmm.
in practice, they are actual racial proxies.
So, Reno, then uh, wouldn't, and I know that you're pursuing your postgraduate degree in the subject matter. I guess your dissertation is going to be on affirmative action and where what it's been, what it's created. In that research and in all the digging you've done into it, wouldn't this have been easier just to say, hey, not enough kids of these ethnic backgrounds are getting in there, so we're going to redouble our efforts in the elementary and secondary schools in their neighborhoods so that when they get to taking the SAT, they've got a better chance of getting a high score that'll get them into a Harvard or the University of North Carolina?
Yeah, Joe, you just hit the nail right on the head. What this proves, so in the dissents in the Students for Fair Admissions cases, the Justice Sotomayor and Justice Jackson speak at length about how there are still educational achievement gaps, gaps in income between Black Americans and white Americans, for
Hmm.
example. My response to that is this policy was first implemented in the mid to late 1960s. And if such pervasive gaps still persist, this proves the policy has failed. And so, what we need to do is address educational disparities at their root cause, which is really in elementary education. It's through encouraging strong families.
Hmm.
Those are, and for example, one of your suggestions that you just said, which is helping students in receive proper elementary education in inner city schools, where there are a lot of disadvantaged children, for example. Those are ways in which you can get students to a standard where they don't need affirmative action to gain
Right.
admission to an elite college.
I mean, I've talked to early education experts who have said that if a kid isn't reading at grade level by third grade, I mean, they're a half a decade or more behind everyone else, and their chances of catching up become slim and none because the factors that lead to them being that far behind by third grade aren't going to change all that much, and their attitudes towards education have kind of been set in stone. So if we're going to change what Amy Coney Barrett speaks of, these achievement gaps and things like that, is this, and I don't want to get you out of your comfort zone, but we speak frequently here about the school choice movement,
Yeah.
and we're seeing in ethnic communities tens, 20, 30% of Black and Latino families are moving their kids out of public school and getting them into parochial school or homeschooling. And I anecdotally remember some research done about 10 years ago that said the fastest growing population of students applying for Ivy League colleges were homeschooled students. Now, I don't, that could be statistical games as well. Where do you start? Where do you go? But it certainly seems like that is what a lot of parents are sensing is the answer. Am I wrong?
You're not wrong. You're absolutely correct. Racial minority families and students, children want options. The issue is, for example, so many of the public schools have become quite politicized. So, me, along with Ilya Shapiro, who is
Mm.
Manhattan Institute's director of constitutional studies, just published today a piece in City Journal explaining, for example, that in California, about 60% of public school students are categorized as Black and Hispanic. Yet, for the past several years, equity advocates have been lobbying the State Board of Education to stop teaching algebra in the eighth grade, to do away with calculus, for example. So it's no wonder that so many Black, Latino, Asian parents are trying to get their kids into charter schools and calling for an expansion of charter caps, for example, are turning to homeschooling, are turning to Catholic schools. The traditional public schools are largely failing at the behest of the teachers' unions. And so it's no wonder that these various racial minority groups want more options.
Well, and a friend of mine has been trying to come up with a way to push back on the whole math is racist movement. Which I mean, you chuckle, but I mean this is scary because these Newsweek and the Washington Post have written pieces about the racial. Makeup of asking kids to go through algebra, go through all of these programs, and I sense that the racism is on the other side of the coin of the people saying, they're never going to figure this out. I mean, that's the same attitude that led them, to the kind of Jim Crow attitudes of the 30s, 40s, and 50s was, they're never going to, they're not intellectually capable of understanding this stuff. And it just offends me as somebody who grew up and went through New York City's public schools during a period where not just the school division, but the city itself was bankrupt and being run by outside forces. We did okay, but then there wasn't a whole level of political intrigue loaded on top of it. So, what do you think is going to be the follow through on this? What do you think the university policies are going to wind up looking like? I presume that all the college admissions directors are going to be scrambling for the summer, trying to figure out how to write their admission standards so that they don't run afoul with the law, or are they just going to shrug it off and say, you know, who's going to bring this to court?
So, going back to the first question that you asked me when we started talking about that quotation from Roberts's opinion, that's sort of a loophole. What we saw yesterday in response to the decision being dropped from various colleges posting their official institutional statements on this was astounding. They all cited that quotation from
Hmm.
Roberts and said, "We will certainly comply with this statement," where Roberts said, in a more sort of holistic way, if tied to experience and tied to overcoming some sort of adversity as student writes about race, that's okay. The fact that colleges and universities throughout the United States felt the need to cling on to that statement in an hour or so after this
Right.
decision came out shows that they are going to, on the books, get rid of the admissions tip provided to underrepresented racial minorities. But we've already started seeing, for example, the New York Times had an interesting piece
Hmm.
published yesterday where they surveyed various colleges and universities, now creating essay questions that encourage applicants to write about what diversity means to them, to write
Hmm.
about and quote aspect of your personal background you feel is so central to you the admissions committee needs to know. It asks about, what is one time you overcame discrimination. So I think
Right.
that is what it's basically going to be, very much, I think, the same thing. It's just going to be phrased in different language that literally seems to be in line with what Roberts has allowed now in his opinion.
So as somebody who's studying affirmative action, do you think this has helped move the mission forward or has pulled it back, Renu?
I think that this has definitely pushed the mission forward for a few reasons. The first being that this is a largely just the symbolism behind this
Mhm.
victory for those who are advocates of color blindness and equal opportunity and protection. After 45 years, since the court first said you can discriminate on the basis of race in higher education admissions in Regents of the University versus of California versus Bakke, the court saying we got that wrong. Grutter was wrong. Fisher was wrong. You can't have separate classes of, we don't have separate classes of citizens in any other aspect of our equal protection jurisprudence. So we probably should not do that in something as seminal as higher education admissions. So I
Mhm.
think for that reason, it's significant and a victory for the United States more broadly. And then I also think it's significant because, it seems as though, again, the universities are they sort of have no shame in these statements they've put out. But at the same time,
Yes,
I think,
punish me, punish
yeah,
me.
exactly. But at the same time, I think, that they do realize they are now going to be under even stronger scrutiny. I think there are interesting responses from various corporations after this ruling dropped, also saying, that they are now considering their diversity hiring goals and programs. So I think a lot of advocates of DEI, of racial preferences, are now thinking, the court has said this is illegal. And so we probably need to be
Mhm.
careful about what we do.
Well, what about extrapolating off of this ruling into the world of business and corporate ESG regulations and DEI and sort of the commercial application of these quotas, Renu? And I'm kind of pulling you a little bit out of your comfort zone for that, and Ilya can thank me later. But what do you think could be applied in the commercial space in the business world, where they're also seeing these kind of campaigns and these kind of movements take foot?
So these decisions won't have any sort of legal effect or ramifications for the business world, the private sector, corporate America. So again, I think it is largely symbolic. What's interesting is, that it might perhaps encourage or make employees feel more comfortable in standing up against
Mhm.
hiring or promotion practices based on race that they could perceive to be like some sort of inherent quota
Mhm.
system, or just violative of equal protection principles of Title VII and what have you. So I think, again, there are no legal ramifications for this, but again, I think corporations and these businesses have taken note. And what's interesting is several major US businesses, ranging from Pepsi to CVS to American Express, filed amicus briefs in support of Harvard and UNC's affirmative action programs
That
in
was
this case,
right.
saying we need this. And basically, the arguments say we use the same policy ourselves.
Mhm.
And so that's why we think it's important to us. So I think, further lawsuits in that arena, it's only a matter of time.
Well, it certainly is going to make the job of human resources director more interesting, just like it will admissions director. They're going to need more buildings for all the files they're going to have to keep. I think Renu Mukherjee, thank you so much. Did I get closer at the end here with your last name? And again, I apologize for being that guy, but I only heard you say it once, and it went right through. So was I closer on the last one?
You were perfect. You said it perfectly.
Oh, well, you're very nice. You're very kind. And again, she's the Paulson policy analyst at the Manhattan Institute working on this. And you said City Journal is where your stuff is that you wrote just recently on this ruling?
Yes, and I'll plug City Journal, saying we have a whole outlet basically of all of our live coverage that we're writing about the implications of the cases, the actual holding. So if anybody's interested, that's a great resource on this.
And any thoughts on today's rulings? Yeah, I know that we have some folks coming up early next week that are excited about that. But have you guys discussed any of today's rulings around the office there at the Manhattan Institute?
So I'll speak for myself. I think I think these 2 days were important days for the court. I think they got all three decisions correct. The
Hmm.
case in 303 Creative, I think, ruling in favor of free expression for the woman Lori, the web designer. I think that was the correct decision, as of course was striking down President Biden's student loan forgiveness plan.
Hmm.
So I think, like, the court had a very strong 2 days.
Well, and my favorite one is the 9-0 ruling in favor of the letter carrier who wanted Sundays off, because I was actually stunned to see that that was a unanimous decision. But I guess that also is given to how well the case has come up through the courts. You have to get the right kind of case to get to that point, don't you, Renu?
Yes, exactly.
Well, thank you so much again for your time. I appreciate it. I hope you have a wonderful Independence Day weekend. And thank you for taking some time out with us today on the Afternoon Constitutional.
Thanks for having me.
And thank you all for watching as well. And we'll be back here Monday, we're going to get into the student loan forgiveness program. So we will get further into that with some of the folks who are involved on Monday's program, Independence Day as well. We're going to be out and about, so we'll try to put together something good for you for Independence Day as well. Until then, for all of us here at the Afternoon Constitutional, so long, and thanks for all the fish.